advised on some legal issues or constitutional issues that might arise in the event that the said law is passed by Congress. Because as stated by Congressman Tumano, even as early as July 30, 1991, in the case of Osmeña versus Comelec, the Supreme Court had already held that any extension of the term of office of an elected official on an holdover capacity is not allowed under the Constitution. And that even under Republic Act 1954, the Organic Act of the Autonomous Region of Muslim Mindanao, the Organic Act is the Constitution, itself the Constitution of the Autonomous Region in Muslim Mindanao. And it is clearly provided therein that any amendment of the Organic Act needs a plebiscite to be approved by a majority of the electorate of the ARMM. Kaya kung magkakaroon ng amendment, by postponement, that would constitute an amendment of the Organic Act, and therefore a plebiscite is needed in order that it could be properly implemented. And also, aside from the case of Osmeña versus Comelec, I think the President should be guided by the pronouncement of the Supreme Court in the case of David versus Comelec, sometime in 1997. In that particular case, the Supreme Court denied a petition to postpone the barangay election because according to the Supreme Court, in any democratic country, you cannot govern without the mandate of the people. And therefore, if an election is postponed, that is in itself a subtle way of extending the term of office of the elected official without the mandate of the people. And that by that principle alone, I think that the election in Muslim Mindanao should not be postponed. Also, the issue of mandate. You will recall that in the case of former President Arroyo, sinasabi nila the President did not have any mandate. And yet there was an election. Ito may election pero ang sabi pa ng iba, walang mandate. What more in the case of the ARMM? If we will postpone the election in the ARMM, then people in the electorate, the ARMM will say, wala ring mandate yan. And so, kung
excuse me for interrupting, but was it Miswari, Nur Miswari, also the election was postponed and Nur Miswari was allowed to continue?
Yes, but then there was no question. It was never raised
as an issue. But the fact that it was that question doesn't mean that it was wrong.
No, but you know naman under the civil code, the law is the law. The non-observance of the law is not an excuse for not observing it at all. Kasi kahit na ba sinasabi lang hindi natuloy yun, not because it has not been observed in the past, we can just correct a wrong by another wrong.
But why was it that nobody raised it at that time? I mean, all these legal arguments at that time were also present.
Well, nobody raised that particular issue. And I think the law governing the election of Miswari was different. And now we have the Republic Act 1954, which is now the Organic Act of the ARMM. And in the case of the Organic Act, it was even submitted to a plebiscite. And so I don't think that we could compare what happened in the Miswari case and the present election of the ARMM. But then we maintain the fact that the law should be followed. And sabi nga lang, kahit na ba hindi, whether or not that law has not been observed in the past, that is not an excuse for anyone not to observe the law anymore.